Expecting Jake, so we should
Couple
have,
minutes.
we have a, we'll have 5 Okay, alrighty, well,
Just,
He knows, because I saw him a little bit ago.
yep, okay.
something happened.
Okay, so we will proceed. Are we ready to go? Okay, so Bill, can I ask you to lead us in Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so this is the Madison Zoning Board of Adjustment. It's April, what is it, 17th? A little bit after 6 o'clock, okay. So we have a number of cases to consider tonight. Actually, we intend to just hear 2 of them. As chairman, I do have discretion to set the agenda, so I have, and since all the cases are represented by Mr. Johnson, we've agreed we'll hear case 2315 and 2318, and we'll address the continuance of the rest later. So with that, then we have a 4-member board. We have a 5th member with Jennifer Scaife, who is our alternate, so for first evening on the board. As chairman, I have the authority, yeah, to raise her to a voting member. And so when we vote, we'll do a roll call vote, and I will ask Jennifer to vote in the 4th position, so she's not put into position of casting a deciding vote. Okay, so those of you who may say, well, what happens? I will vote last, so if there's a tie, I'll make the deciding vote so that you're not dependent on an inexperienced member. Okay, so with that, we'll proceed with case 2315. I'm sorry.
Yeah, do we have to do these things first?
No, 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 we don't have to do that first.
Okay.
The agenda's mine. So we will do the public hearing. Okay, 2315, which was continued. Kate, you want to read the notices and?
2315 continued October 18th, 23, November 15th, 23, January 17th, 24, February 21st, 24, March 20th, 24, appeal from administrative decision from Matt Johnson Esquire, Divine Mill and Branch, PA, agent for Keith and Allison Kellerman, 21 Haven Road, tax map 128, lot 21, to determine whether or not their circumstance allows for short-term rentals relating to a denial from Robert Boyd, code enforcement officer, dated August 16, 2023, as to Article 5, Section 4, Section 4.2 of the Town of Madison zoning ordinance.
Okay, and all the abutters were properly notified and we didn't get any?
Right.
Okay. We've gone through this before, but we do it formally. You have a conflict of interest, George?
No.
Nope.
No?
No.
Jennifer? No. Okay, no conflict of interest on this board. There is a waiver request. There are no dimensional issues at stake here, and so we need a motion to accept the waiver request. That the waiver is so that we do not have a certified plot plan, but since there are no dimensional issues at stake here, the certified plot plan is meaningless for our deliberations. So that's the reason why we would consider waiving.
So moved.
Oh, he's so moved.
He moved.
I'll second.
Okay. All in favor?
Aye.
Aye. Okay, so we've,
That was quick.
okay. Regional impact. Does anyone think this case has regional impact?
No.
No.
No. Okay. Okay, so can I ask everyone who intends to speak to this case to identify themselves? Okay, would you, well, why don't you all stand and we'll swear you all in. Do you swear that the testimony that you give pertaining to this case will be truthful under penalty of perjury?
Yes.
Okay. And then when you speak, you can identify yourself. if someone decides to speak and they haven't been sworn in, then I ask you to identify that, and then we'll swear you in at that point. Okay.
And you have to go to the microphone.
Yes, everyone who needs to speak needs to move, well, we probably need to move, well, no, we put it there for a reason, right?
Yeah.
Yeah, right, okay. So, Mr. Johnson?
Sure. I make it tall.
For you.
Long way.
I feel a little better now that it's not super easy.
It's not you.
It's usually me. There we go. Members of the ZBA panel, thank you for your attention to this. I know this has been a long-running process. This case that you have before you, 2315, involves the Kellermans at 21 Haven Road. They bought their property in December 2022. I'm going to hand up two letters in a minute for the board to consider. One is a letter from Silver Lakes Association, which provides some background relative to the unit they have, plus what the other units are and how these units have been operated and how they've been rented out over time, to provide some context to that. And I also, Mr. Kellerman, and also a neighbor of his will testify with the, if need be, relative to the prior rental use. The prior property owner didn't, the prior owner of Mr. Kellerman's property didn't want to get involved, and so that's why we don't have the same data that we necessarily have, but we have neighbors who can testify to the fact that the property he acquired in December 22 was actively rented, and he's continued to operate it the same way. And Mr. Kellerman can testify to that and answer any questions about it. Before we got there, though, I did want to make a legal point, and I thank the town of Madison for giving me some of the prior zoning ordinance, because at the last ZBA meeting, there was some discussion about the iterations of the zoning ordinance and how that applied. And just a couple points that apply both to this case and the next case, and frankly all the other cases, is the notice of violations that prompted this whole discussion all say that the March 22 change to the zoning ordinance clarified that the residential use of a property for a transient use, as now defined in the zoning ordinance, was not permitted, and that is what brought the administrative enforcement actions. And I've gone back and looked through, I haven't gone back to 1990, but if you look back through a series of the zoning ordinances, the first time when all of these pieces were put together for the town to be able to make the argument they're making was with the 22 ordinance changes. I'll note there was some discussion last time in Mr. Kellerman's in the Edelweiss district. The definition, that section 4.6 of the zoning ordinance, has not really changed by any sort of substantive way, going all the way back. The issue is that in 2022, the town added a single-family home definition that never existed before, going backwards, and they also changed the dwelling unit definition. And that's important, because only in 2022 did the definition of dwelling unit include the phrase for non-transient use. Because in 2018, a definition of transient and non-transient came in, but in 2018, the definition of dwelling unit just said for residential uses, and there was just no concept of a transient aspect to it, or like that for a period of time. Only with 2022 did that happen. And so I went back to from 2010 forward, there were definitions added, but it wasn't until 2018 where they added the transient definition. They still didn't change the definition of dwelling unit. And then in 2022, they changed the definition of dwelling unit to link it to the definition of transient and non-transient use, and say the dwelling unit only was only included use that was for non-transient use. And so that's the first time you had a temporal or a time limit type of definition in the dwelling unit definition. And so I would submit that the standard of the test is whether the property was being used for short-term rentals prior to the change in the zoning ordinance in March of 2022. And in fact, I would submit that that's a position the selectmen have taken, because that's the notice of violations all reference the clarifications in a March 22 zoning ordinance, which now, by their view, says that short-term rentals in a single-family home are not permitted by trying to rely on the new definition of dwelling unit, which says it has to be for non-transient use. So I want to make that point. After that, we would represent, and maybe at this point I'm going to hand up these letters for the board. I'll do one at a time. This is just, the first thing I'm handing you is a letter from my client, Mr. Kellerman. The context there, I think, is important for, and you've heard some testimony in prior hearings about this, but it walks you through the due diligence that Mr. Kellerman took in December of prior to December of 2022 in deciding whether to purchase the property. And what you'll see from this is that the guidance on the town website and the information was confusing at best and frankly a little bit misleading at worst relative to what could and could not be done on the property. And so I raised that for the board just because I know the board has had some questions about, well, you know, you bought the property, what sort of due diligence did you do? And so I wanted you to be aware of that. The second letter that I wanted to hand up is just from the Silver Shores Homeowners Association. And this letter provides context for how these properties, including Mr. Kellerman's unit, has been used historically and why some of the points I made in my broader legal argument apply relative to the impact that this interpretation and this approach that the select board is now taking, how that would impact the Silver Shores Association. The author of that letter, Mr. Audette, is present here, is more than happy to answer any questions the ZBA, the board has for him. And Mr. Kellerman has one of his neighbors. At this point, I'd ask his neighbor to come up and just explain to the ZBA board the prior rental history of the property that Mr. Kellerman bought, just so the board has some context for that. If you could.
One point of order. Jake Martin has joined us. He's a regular member of the board. Since I've already elevated Jennifer Scaife, we can continue with that way, but I'm going to ask your opinion. Would you prefer that we return to the same 5-member board we had before? I'm willing to do that, to allow Jennifer then to be the alternate and let Jake stay. On the other hand, I've already done that, so if you want to continue with the board the way I have said it at the beginning of the meeting, I'll let you make that call.
I think there's probably value in having a consistency of membership from the prior board to the present board, just because the issues the cases somewhat, while they're separate, they overlap a little bit in terms of the legal issues and the ZBA decisions, and so I think that's probably cleaner.
Okay, then we'll do that. I'll let Jake operate as the 5th member of the board, and Jennifer, you're back in your training mode, you can relax.
I apologize, I got caught up with work.
We get it,
Yeah, he's a policeman, so, you know,
we get it.
shifts, yeah, you get it, okay. Because he missed the beginning of your argument, I will give you the opportunity if you wish to summarize that shortly. I think he understands what you're talking about, but you could,
Yeah, I'll be very brief. So the 2 letters you have in front of you, one is from the Silver Lakes Association, which provides some context about how the properties have been used, including Mr. Kellerman's property. What I noted before is Mr. Kellerman, the prior owner of the property, did not want to provide any records to Mr. Kellerman about prior rental of the property, so we need to go about this a slightly different way. The other letter that you have is from Mr. Kellerman, which provides some due diligence that he did. They purchased the property in December of 2022, and the ZBA has had questions of some of the unit owners of like, what did you do to look at it? And that maps out what he looked at and what appeared to him to be indication that short-term rentals would be permitted. And he did know, in fact, based from the prior owner, that the prior owner had used the property for short-term rentals. So there did not seem to be anything that was inconsistent with that. I raised a legal argument based on what some of the discussions at our last ZBA meeting, where I thank the town for giving me the prior zoning ordinance, and my point was, if you look at those zoning ordinances, not until March 2022 does the definition of dwelling unit change to include and say for non-transient use. And so until 2022, there is no limitation on time relative to dwelling units, and I would submit then that that's what the selectmen were seeking to enforce, because the zoning ordinance changed and the dwelling unit definition changed, and that the threshold then for determining whether it's a pre-existing non-conforming use has to be whether the property was rented on a short-term basis prior to the change in the zoning ordinance in March of 2022, and respectfully submit that the zoning board got it wrong when they looked back at prior zoning ordinances, because those prior zoning ordinances did not have definitions that would allow the enforcement the way that the town Board of Selectmen is now trying to do it. So that it's 22 that is the key factor. And at that point, I was going to ask Mr. Kellerman's neighbor to come up and just explain to the ZBA his knowledge of how the property that Mr. Kellerman bought was used prior to Mr. Kellerman buying it. And just identify yourself for the ZBA board.
So my name is John Knight. I live at 10 Haven Road. I'm a full-time resident here. I've owned the property at 10 Haven Road since 2007. Before that, I owned property in Edelweiss that I had purchased back in '85. And those properties, until 6 years ago when I moved up here permanently, I was a transient person that was coming up from Massachusetts, using my house every on the weekends and vacations and things like that. Since 2007 that I've been there, I know of at least 5 houses in Silver Shores that have been rented out over the years. As far as Keith's place goes, when I first moved in there, there was a person, can I say people's names or no?
What's that?
Can I just say who was there?
Sure.
Okay. So Alan
It's
Davis.
informal.
Okay, Alan Davis owned the house when I first moved in there. And he was a full-time summer resident, and he wintered in Florida. After he sold the house in 2015, I believe, Alan Moore bought the house. And they had rented quite a bit over the years. And then when Keith bought the house in '22, he also rented the house. So as far as, I know that there's been a lot of controversy about people using the roads and being too busy and having police go there and all that. Since '07 that I've been there, I've known that the police came one time because of people renting, and that was at Alan Moore's house, at Keith's house now. And the reason that they were called, that the owner, Alan Moore, actually called the police to have them go in there because he's got a security camera, and he noticed that somebody that was renting had broke into a shed. And so there's never been any noise ordinance things or anything like that going on since I've been there. I use the house even when I was here part-time. Almost every weekend I was here. And then, probably a month in the summer for vacation time that I would take as well. The people that Keith had been renting to, obviously he's been pretty smart about what he's doing and screening people, because we haven't had any issues that I've heard of other places that have had noise people, drinking parties and all that stuff. He's rented to couples, maybe their kids come up for a couple of days or whatever, but they've been respectful to our neighborhood, and in my mind, I think you should let he's still continuing to rent. He hasn't been a hindrance to the town that I can see. So,
Thank you.
And I would just ask Scott to come up and just explain a little bit, sort of the history of and how the Silver Lakes,
Hey,
Silver Shores Homeowners Association.
1 second, do we have somebody want to come in here?
You wanna come in? Yeah.
Yeah.
Thanks.
Come on in. I think there's a seat back there behind the camera. Okay.
This is just a letter from me and my wife about the rental car history. Scott Audette, 48 Saxon Road. I've owned the place for 27 years. In my very early days, I rented my house a few times, but when my children all graduated college and stuff, I didn't need to do it anymore. We are here probably 85% of the time during the year. My wife comes up every Wednesday and stays till Monday. I come up Friday nights and stay till Monday morning. During the summer, I'm here more. Winter time, I'm here snowmobiling all the time. Not as much the last few years, but all I can say is that as long as I've been here, Alan Davis never rented. Alan and Kimberly rented all the time, especially in the fall, winter, and spring, because they were summertime on the boat. They used the place maybe Thanksgiving and Christmas. The rest of the time, they rented it. Some renters were there for 2 weeks. One time they had a renter there for 6 weeks, but as little as a week. Big weekends, a lot of it was weekends, you know, for skiing. People come up, ski, use the place, ski for the 3-day, 4-day weekend, then go home. As far as trouble in the neighborhood, we all kind of watch each other. If somebody does rental, everybody keeps an eye on it, you know, for the person who owns that house, just like any other house, to make sure there's no issues. I'm vice president of the association right now. I was president for 15 years, and then another gentleman's taken over for a few years. And that's about it. I mean, there's never been any trouble in the neighborhood. We don't allow it, even with our own people, like kids coming up and cousins and stuff. We just don't allow it. We don't want the police down here. You know, we want to just relax for the weekend. Also, in that charter that's recorded with the state, under the rules and regulations, it states that we are allowed renters, and that each person owning each property has to maintain their renter and make sure there's no issues. And it's right in the charter, recorded with the state, that we allow rentals. So I just don't see how the board can change the charter on our association. I don't see how it's legal. So if this doesn't go Mr. Kellerman's way, then the board association will step in, because this won't, you know, you're not changing our charter. It's recorded with the state. And that's the way it is. So other than that, it's been great there. You know, I've been there 27 years. My father owned the place before I did. And, I think you should be allowed to rent. It has a history of rental, and it's simple as that. Okay? Thank you.
Should state their name.
Yeah, hi, my name's Keith Kellerman. I'm the owner of the subject property at 21 Haven Road in Silver Lake. What I wanted to come up and speak to you about was the due diligence and the intent, right? When my wife and I purchased the property, we put the offer in I think it was October of 2022. We closed in December 2022. We were looking to have a property that we could rent out on a short-term basis for two primary reasons. One, the benefit of being able to use the property, and two, to offset the high cost of purchasing a second home. For us, this is part of our strategic retirement plan, much like my neighbors who you know, bought the property to live in this beautiful town, you know, in retirement. That's part of our strategic plan as well. But again, you know, at the point that we went to the home viewing, we did discuss this with the seller's agent. She did disclose that, you know, the prior owners had rented the property, that she didn't believe that to be illegal to rent on a short-term basis in the town of Madison. She did mention that there was some political discussions going on with respect to the Idlewice district at the time. And so I said, okay, I'll I'll start my due diligence actions here. We put the offer on the property and we started reviewing. And you'll see, summarized in my statement letter, some of the key points that, that I carried out here. I just want to quickly recap on some of those things. So, sorry.
For the record, this is on page 2 of your letter.
Correct.
The bullet points.
Yes.
Okay.
Yeah, so, I did start with the town website, right? And if you scroll to the bottom of it, it does say if you are renting or planning to rent your home on a short-term or long-term basis, that you should submit a rental affidavit, primarily to disclose where the owner lives, right? Which I did, and we did that shortly, after we purchased the home. And then I went further. I did review the articles that were voted in March of 2022. Primarily, I focused on the 2 articles that were discussed where short-term rentals were specifically highlighted, and those articles were defeated. So I said, okay, the articles that mentioned short-term rentals were defeated, right? It didn't quite register to me, the change in definitions, because they were subtle, right? Just adding the word transient didn't necessarily trigger in my brain that it might make renting the home illegal. At the same time, I was concerned that, well, later on when I thought about that, what does that mean for me who owns the home on as a second home when I come up on the weekends? Because per the definition, if I come up for less than 30 days, am I illegal too? So that I found it to be confusing, to be honest with you. So anyway, nonetheless, I also continued to review what was being reviewed at the town planning board meetings, so in June of 2022, there are draft regulations that were being reviewed at the planning board. So that told me that the town was starting to consider regulations for short-term rentals. So I said, okay, well, the town's directionally going towards regulating. I'm fine with that. I would want to have regulations in place for short-term rentals, And so that was essentially my due diligence. I went into this thinking that it was not an illegal thing, or the town would not perceive it as being illegal. So anyway, that's my primary statement with respect to that. We are very careful about renting, mostly because we love the property and we don't want to have any issues whatsoever. We've never had any issues. You heard from my neighbors who also corroborated that as well. That's all I have.
Thank you.
Thank you.
The board, of course, can ask questions of any of those who spoke, as well as Mr. Johnson. I do have a couple of questions. So, first one is, well, just a general comment for the public, and that is that this is a review of an administrative decision. So, unlike a variance where it's absolutely determined by the individual property, we have an obligation to be a little bit consistent with previous decisions. However, each property is considered on an individual basis, right? So it is possible to have a different outcome for an individual property on the assumption that, the board finds that there is a sufficient difference between that and a similar property that didn't. I do want to ask your clarification on one point, and that is that in our previous decision, also for the benefit of the public, the essence of this particular request is this particular property grandfathered? Because if it is grandfathered, then it does have the right to continue in its use, whether or not you agree that it's legal or illegal, right? So at this stage of the game, because we've already made a decision earlier that another similar property was not legal, that the point is, if we determine that it's grandfathered, then that solves the issues, right? So, however, the issue of the grandfathering was not based on the definitions of the dwelling unit, but on whether or not it was commercial or not. In other words, the board wasn't contesting that we had a clear issue of transient versus non-transient usage, less than 30 days or more than 30 days. The question the board had been raised in specifically in Edelweiss was that in contrast to the rural residential district, Edelweiss specifically prohibits the use of commercial use and business use, and that our definition of understanding what commercial and business use turned on that particular thing and not on the question of the definition of a dwelling unit and transient. So I'd just like to ask you if you understood my point there and how you respond to that.
Sure, I understood your point. With all due respect, the ZBA got it wrong with that. The Supreme Court has answered the question of how you interpret this question. If you're using the property residentially, it's a residential use, and the fact that it's being rented for long-term or short-term does not convert it to a commercial use. I'd also submit that the language of 4.6 in Edelweiss cannot be read the way the ZBA is reading it, because it says single-family usage, but it also allows home occupations. So it's not as narrow or tight as what some people wanted the ZBA to believe relative to the limitations on it. And so when you couple the actual language and the fact that it does allow home occupations in it, which arguably that's, I mean, if were you to call it a short-term rental as like a business, which I don't think you can under the Conway v. Kudrick decision, but even putting that aside, say hypothetically you did, the ordinance already says you can have home occupation, and so you're using the property there. So I think you get there either way, and so I would submit that. And the other point I would make, and maybe I misunderstood ZBA, so I appreciate the chance to clarify. The discussion at the last meeting talked about going much further back in terms of having to show that it was a pre-existing short-term rentals much further back in time, because as I understood the board, you were saying that basically you'd have to prove that you were renting the property back in the 2010s or even before that because of your interpretation of what the Edelweiss district stood for. So I had understood the commercial point, but I also had understood the point that, at least from your opinion, you had to go, the cutoff date was much earlier, which is why I made the point of saying I really think the cutoff date has to be March 22. And in fact, all of the enforcement was predicated on the fact that the ordinance changed in March 2022, and then there was a flurry of these notice of violations. None of this ever happened before, and the letter doesn't say you've never been able to do it, but oh, by the way, we're now coming around. It says we've clarified it in March of 2022 that it's not permitted, and then we had those. So I don't think analytically the deadline or the trigger point for whether as a pre-existing non-conforming use can be any earlier than the changes to the zoning ordinance passed by the voters in March of 2022.
Okay, and just to clarify what that discussion was about is that there were two models of what grandfathering is, and one model is that there are 3 periods of time before 1987 when our zoning ordinance came into play. Any home that's been used for short-term rentals and can document the fact that it goes before us clearly clearly grandfathered. The argument then that we had last time was whether the period between 1987 and 2022 was that a separate period that the zoning ordinance didn't speak to short-term rentals specifically, didn't, and therefore they can't be considered illegal. Or can you apply the definitions of the things that was a discussion, which then meant that there are basically only 2 periods, before 1987 and after 1987, at least for Edelweiss. So that's what you're speaking to right now. And so the question is whether, well, it's not so much about the iteration of the ordinance as it was, did the ordinance suddenly change later so that there's another date besides 1987. And what we established was that clearly by 1990, the definitions that we were discussing last time were already in the ordinance by 1990, so that's not, the date is somewhat irrelevant because the house, we're talking about a period that's much later than that in any event. So, okay, so questions from the board? Other questions? Does anybody else wish to speak from the public?
Shouldn't you do abutting first?
I'm sorry?
Point of order?
Yes?
Should you ask if abutting people go first?
I'm sorry, I didn't hear
Budding
you.
people,
Abutting.
abutters.
Butters, oh, yeah, alrighty, that would be fine. Are there butters that wish to speak? I'm not seeing any abutters who wish to speak. Is there anyone else that wishes to speak? Okay,
Yes, thank you, Mr. Chairman.
state your name.
My name is Bill Dempster, 157 Door Drive. I have here for the board a timeline, which would certainly help the board in their determination. It's pretty clear on this piece of property. This is a rural residential piece of property. And what the letter that was sent was section 4.2 from Code Enforcement Officer Bob Boyd. There was some clarifications on here on the timeline. You can see when the 4.2 was adopted in 1987. In March of 1994, I did in fact, go back and start from 1987 right up to 2022. Whatever I could find, and then I went in town meeting, so I'm pretty clear this is factual information you're going to be getting. And if you need anything, I can provide that information for you. But Section 4.2 amendments clarify what permitted uses and special exceptions were, as the 1987 just said, because we are a permissive zoning ordinance, those in 1980 said what is permitted in that area, flat out. The 1994 broke it up into what's permitted and what's permitted by special exception. And that is what is existing now. And it existed when it was voted on in March of 1994 through the 2022 ordinances. So it's pretty stable, hasn't changed at all. You can see the three owners. The current owner, prior owner was Alan Moore, rented short-term. That was in the Granicus report, and that was verified by the prior testimony. The owner prior to that was the Davis family from 1969 to 2015. We have located, contacted, and are awaiting response from 4 members of that family as to whether they've rented when. We have not heard back yet, so it's sort of a bit up in the air, although prior testimony was that Alan Davis never rented. I'd like to get, me personally, I probably have clarification, but that's up to you guys. And then when it was rented, the first compliance letter, and then the notice of violation, and then the appeal. So it's pretty straightforward. If you look at section 4.2, and that's exactly what Officer Voigt did, the current use of this property as it is an STR is not permitted. It's not listed as a permitted use. I don't believe there's any other use of that property with regards to a bed and breakfast. It appears that it was always been some type of summer home, and then when they rented it out when they weren't staying in. And that's exactly what was in the regulations, which were approved by the state, I believe, in '69. I don't have a copy of that with me, but it did allow. That's part of the deed.
I'm sorry, it did allow
Silver Shores.
Silver Shores.
Silver Shores, yeah. Now that was in 1969, prior to zoning for rural residential, which is in March of 1987. I don't know which takes precedence over what. That would probably be a question for an attorney to answer that in this situation.
Okay, so just to make sure, because we're dealing with matters of fact here,
Yep.
you're attesting to the fact that the Charter of Silver Shores allowed the short-term rental beginning in 1969.
No, it didn't specifically say short-term rentals. All it says was the owners may rent the
May
property.
rent, right, excuse me, yes, so we don't have a definition
No, we
that
don't.
distinguishes 30 days plus or minus from, but
That's correct.
rentals were
All
allowed.
it said, and it was, I think it was verified by Mr. Dent.
Right,
There was in the
which he spoke,
regulations.
yes.
Bill, your extras.
Did Kate get one of those?
Yes, she did.
Okay,
Uh,
okay.
We got two.
So,
Give one to Kate if you could.
I got
She
it,
already
no, I
got
got
one.
it, I'm on
Oh,
it,
she got
I'm
one.
watching.
Thank you.
Sure.
okay, so just to clarify,
Thank
before you sit down for the board, the question that we are trying to answer is whether or not this property is legitimately grandfathered under the existing ordinance. Right, I mean, that's what we're trying to answer, so,
That's correct.
do you have any questions for Mr. Dempster? Okay. Thank you. Oh, go ahead. if you-
I
if you're
just
not
had a
done.
couple additional points. One is the comment with regards to, the only notification folks received was after March of 2022. For those who have been through this, the board, select board actually sent out letters of violation in 2021, prior to the March 2022 vote. Those letters were pulled back because of what the decision was in the Cooter case, and I think the board and their attorney at the time got a little gun shy when they rescinded those letters. But there were letters sent out prior to the March 2022 using section 4.6A and 4.2. One other question on the home occupation. It does specifically list the home occupation definition in our zoning ordinance. So it tells you what you can and can't do, how many you can have, and what's permitted.
Mr. Dempster, under that regulation, does it specify if you have to live in that house?
Yes, it does.
Yes, it does specify, and what is the specification?
You can look under the definition in 2020, the 2022 ordinance. It'll tell you what's required of having a home occupation.
I can pull.
Okay, yeah, someone pull that up just
Yep.
for the record.
Can I ask a question?
Yes.
When it says home occupation, occupation can take two meanings here. One is the
It's
property
occupies.
occupied? And the second is, if I'm living there, am I doing something as a career or an occupation? So if you look it up, I assume that when it says home occupation, it means I can live there and run, work. Not that it's,
You would have to look at what the actual
Yeah,
definition
yeah.
is. I'd prefer to
oh, yeah, yeah.
Yes, we're gonna read that.
to that definition.
That didn't change, so.
It's in the back. ma'am.
Well, the definition is, but I also want to read the,
4.2.
yeah.
Do you have any further questions for me?
No, you can sit down.
Okay, thank you.
We can ask if we do.
Thank you.
Yeah, 4.2, village district, we want Edelweiss, right? Because Edelweiss is the one that,
No, this
No, we want the
house is
regular.
not. We want
Right.
rural residential district.
yep.
Mr. Chair, can I comment on the 4.2 question?
Yes, you may.
Thank you. So, under 4.2, under the 2022 ordinance, it says single-family houses. And what I think is important is there was no definition of single-family house in the zoning ordinance until 2022. That was one of the things that was added in 2022. The single-family housing, all it says is, all it refers back to is any building containing one dwelling unit. Now, in 2022, dwelling unit talks about transient versus non-transient, but that's the first time.
That's the first time.
And so before that, dwelling unit only talked about residential use, and there was no definition of single-family home. So I just want to make the point that, in my perspective, it is permitted, it's single-family houses in a rural residential district. This is a single-family house.
Right.
And if someone is using it to live in it, even on a short-term basis, under the ordinance prior to March of 2022, that's a permitted use. And the other point I'd make is that I do think if the charter for Silver Lakes is dated 1969 and it allows renters, I believe that supersedes any subsequent zoning ordinance, because that is an agreement and a permission to rent the property that predates the introduction of any zoning in Madison. And so that by definition is a pre-existing non-conforming use and should implicate and really should be a basis for the ZBA to, at least for this property that's in the Silver Lake Association and has that added issue to it or added additional grandfathering basis to consider that.
Right.
Chairman, I
Okay.
have a question for you, if that's possible.
You have a question for us?
I have, if I may make one other comment.
Go ahead.
It's interesting, Attorney Johnson brings up in fact, if it's an existing non-conforming use, does that now fall under 1.3C of our zoning laws?
The short answer is, just a moment, 1.3C guarantees the right of any legally existing, if a crack house was in, can't continue even if it was there before 1987. It has to be a legal use. But if it was legally in use before 1987, then 1.3C guarantees that, C? No, 1.3
C.
C.
But I believe, Mr. Chairman, it also talks about discontinuance,
Yes.
and I hate to use this term abandonment, but discontinuance, and it gives a time frame in our
1
zoning
year.
laws for that.
Right, yeah, so, that's true. Abandonment, is a condition that if it, the short answer is if a use was abandoned during the time frame of the validity of the zoning ordinance, and it was intended to be abandoned, that is, there's not some explanation as to why it lapsed, but it was intended to be abandoned, then that's correct, then that, it loses its, let's see, Mr. McKenna, right?
Correct, Paul McKenna.
You've already been sworn in, correct?
Yes, I have.
Yeah, please
You
come
have
up
to
to the
come to the-
microphone.
With all due respect, I'd like to disagree with Attorney Johnson. As far as the select board goes.
Please state your name for the.
Paul McKenna.
Okay.
I've had a home here for 36 years. As far as the select board goes, because it was overwhelming to try to do all of the short-term rentals at once, they broke it into two parts. Post-March 22 and pre-March 22. They have not made a decision on going pre-22 as of yet. You seem to think that they've taken it, that's their approach. You have a different approach. I entirely disagree. I have been to all of the select board meetings, with the exception of maybe 2 in 4 years. Another thing is, you had gentlemen come here and tell everybody how there's been no problems. Its burden of proof is upon the owner to prove that there's been no problems, and it's up to him to prove whether he used it as a short-term rental. Just because somebody comes and says, hey, I know he didn't do it, that's not ironclad. Bring some paperwork. Another thing is, the man talked about a charter. Did he bring a copy of the charter?
Yep,
You should submit it.
well, I can't submit it, it's the original copy, I'm not giving it out.
There's actually,
He has it in the affidavit
Okay.
showing the paragraph of
Okay.
renting.
Okay.
Address the board.
But I think there's more to it as far as your insurance binder stating that it's a rental, your mortgage stating that it's a rental. I think burden of proof, that's not enough proof to have somebody come here and just say, oh, it's good and there's never been a problem. Anybody can do that for a friend.
Okay.
I have a question about the charter that's attached here. Is this the full charter, or is this just?
No, it's just that one page showing that we allow all the houses to be rented out if they want to rent them out periodically.
Well, I have an issue that nowhere in here does it actually say. It just alludes to renters of Silver Shores property.
Right.
It does not specifically state that properties can be or can't be rented. And then, so this is 2 pages of how many pages?
I don't know.
Is it possible to get just a copy of the full?
Yeah,
Not tonight,
I
that's
can have it made, yeah.
Because I would submit that this is obviously the pieces that you wanted us to see and not necessarily the full context of the HOA agreement.
I think this is a copy right here that you could probably have, but the actual full one.
So just to clarify, the point is under general regulations, paragraph 9 is the one which refers to those renting property should use discretion as to the number of persons allowed to use property in the Silver Shores facilities. Is that the effective statement that you're referring to? Or are there others?
There's
the
the last line of the
last line of the statement of purpose and renters, okay,
I would submit the last page, paragraph 3.
okay.
There's a, when I read this, may be rented for occupation as a residence. Is your job to provide as a residence, or is it to occupy it as a residence to live in? That's what you said earlier, Doug.
It's also page 2, under enforcement, the second paragraph, which talks about this is especially important in rented cottages.
I didn't see that. Where's that exactly?
Oh, I'm sorry. So it's the second page,
Oh, second
under
page.
enforcement, it's the second, no, I'm sorry, it's the second page of the regulations. Under the enforcement heading, it's the second full paragraph, and the parenthetical sentence at the end.
Yeah. And do we have a
date.
a date on any of these things? Silver Shores, Madison, New Hampshire restrictions, for example, seems to be one of the clearest about allowing rental.
Is that a separate document from the rest of the?
It's the code enforcement part of the original charter. Under the restrictions and stuff.
So it's part of the same document.
Right. This is we just printed out the page that shows rental of it, the rental part of it.
Okay. Okay, so it would seem that there is relevance to the question as to whether the Davis family, who owned the house until 2015, rented the facility out because the question of abandonment is relevant in this case, because if the Davises owned it and rented it out, say from 1969 to, let's just say
2015.
Just say, if they rented it out until 2015, then there was no abandonment during that time frame. And then Mr. Moore rented it out from 2015 to 2022. There was no intended abandonment. But on the other hand, if the Davis is for 10 or 15 years of this long period of time, that's 45 years they owned the house in round figures. If they intentionally did not rent it, I mean, I could understand if somebody said, well, they rent it some years and some years they don't, and some years they do and some years they don't. But is there consistency through that? Then I think we can say, well, okay, they were renting it. If on the other hand, they intentionally didn't rent it for a period before the sale, then that does constitute abandonment. Mr. Johnson, you wanted to say something? Yes.
Yeah, if I would, thank you for the opportunity. I think the abandonment or discontinuance analysis in this case is
Yes.
slightly different than how you're framing it. I
Go
don't
ahead.
disagree that in the ordinary course, the analysis you're talking about, the most zoning ordinance, Madison is no different than most of them that has some sort of abandoned, it's non-conforming, but if you don't continue it. But here, it's a charter position, it's an association with the charter that allows rentals. So I don't think the analysis can be whether an individual unit in there rented or not rented. It would have to be whether there was some showing that Silver Lakes Association as an entity abandoned or changed or decided, either informally or not, that we're not going to allow any more rentals and there's going to be no more rentals in the property, because this is really a charter provision that allows a unit owner to buy it. And so like when Mr. Kellerman bought the property, he would get a copy of those restrictions and those provisions, and they still allow. So I would submit for an association, when we're talking about this type of provision, there would have to be evidence that the association as a whole abandoned their provision to allow renters. And that, I think that's how the ZBA needs to look at it for this set of circumstances, given the nature of the right we're talking about here.
How long has this been in association?
Since 1969. when was
It has been.
built. Yeah.
Okay.
Oh, okay, so any questions from other members of the board? Let's establish some fine. Oh, yes, other comments, okay.
John Cancelarich, Melrose, Massachusetts. Just two questions I have just about this whole charter.
Excuse me, also state your connection to our town, since you're...
I own a second home in Edelweiss. I'll start first. Thank you for having me. Thank you for allowing me to speak. What I did, I'm going to paraphrase this back to the Supreme Court working stiff case to illustrate the similarities between what we have here to Madison. So I used Madison in the 2018, much like we did before with the Edelweiss case, and we look back to 15 as well to see how it worked in 15,
Right.
but I used 18. The key points, once again, what we established, once again, our ordinance established permissive zoning ordinance. So it prohibits all use that are not expressly permitted based on Article 2.3 and 4.6. Okay, when I look at 4.6, we look at that and some of the key definitions we have to use. If a definition is defined, we use a definition because it's defined in our ordinance. If it's not defined, we use common language. Things we have defined, just like in the Edelweiss one, motel is defined. It's a building, series of buildings which lodgings offered for compensation with direct independent access to and adjoining parking for each rental unit. This one lists bed and breakfast, a privately owned occupied residence with guest house by special exception only, okay? And then also it comes in, I'm gonna explain why commercial use is defined in our ordinance, is any use involving in part, whole, the sale of merchandise, materials and services, but not including home occupation as defined in this section. Okay, how this all works out, if you look at the ordinance as a whole, you start looking at it, you look at rural residence, it defines what is permitted. So basically it's rural residence is farms, wooded lots, and so multiple dwellings are permitted in addition to single-family homes. But the only kind of public lodging that's potentially is allowed in here, if you look at it, is bed and breakfast facility. So what your ordinance is trying to do, if you look at it, you have section A of 4.2, permitted use, describes farms, woodlands, and then you look at special exceptions. It's trying to define usage. How is that house used? He keeps saying, oh, it's a house, you can rent it, it's just a house. Well, a professional office can look like a house. A nursing home can look like a house. You know, all this stuff, private school, daycare facility. These are all house and structure, but what you're doing here by special exception is defining usage, how it's used. It's furthermore, if you look at other ones, when you go from rural resident, when you go to village district, it shows you again how it says permitted use, everything you can do in rural resident, and then it says by special exception, it gives you more usage, restaurants, retail, office buildings. As a whole, our ordinance is defining what the usage is by special exception here. And the last one we go to is commercial. Any commercial use, which we have defined as a term, as well as everything in rural resident. So you're using that. That's how this whole structure of the zoning ordinance works. In my opinion, a couple things. Number one is, as we talked before, we define kind of what a rental property is. We saw it as a motel, which is defined. You could look at it, okay, maybe it's like a bed and breakfast. Could be kind of like a bed and breakfast. Just because these terms aren't exact, but it could be something like that. If it's any of these, first off, it's a motel, it's not allowed. But if it's similar to a bed and breakfast, they should have gotten a special exception. Special exceptions are extremely important in our town. We're trying to protect the rural resident area. What a special exception does is it allows them to notify abutters, so abutters can hear it. We have a public hearing, and it satisfies the strict restrictions of what we're trying to do here. That's how our ordinance is set up. So that's how our usage is defined in rural resident. So it should have, a couple of things you can look at it. One is if it's a motel, then it's not defined. The second part you could look at it is, well, maybe it could be, but he didn't follow the proper procedure, which is to have a special exception meeting and allow the town and property owners to do it. So he never followed the proper procedure to do it. So it is not allowed. Other things I'd like to just comment on is he goes on and argues about the dwelling units. My whole thing is your job is to find out what you feel is it fits the mold, as I said before, motels, which is defined, possibly bed and breakfast, but you have to do a special exception for that. And it is commercial use in its true form. Once again, in his previous one, he didn't mention here, but as the Supreme Court ruled in this case, we don't have to worry about construe the Madison ordinance to lead to absurd results, like i.e. second homers can't use it for 30 days, was mentioned in this article. And then I want to emphasize, Supreme Court said the ordinance does not unconstitutionally vague merely because it couldn't be drafted with greater precision or wording. So it doesn't precisely confirm the one standard which the ZBA is looking for. We know what this short-term rentals are. We know they're motel style things, possibly a bed and breakfast, but that defines a person living there, but it's close to that. So regardless, it's not defined, or they should have got a special exception. If they don't get a special exception, then it's never been legal. And lastly, it says you really just need to be based reasonably on evidence. Okay, so use your best evidence for this. In conclusion, a couple things. One is on On charter, I'm not a lawyer. I really think you need to follow a lawyer and not just take the word that he's saying, because typically a charter or a deed is just, it's a group of people agreeing upon something. So they signed it, you have 10, 20 people agreeing upon something. That's all it is. Typically, when you look at deeds and stuff, not a lawyer once again, is you look at which is more stringent. Is it the federal, state, and then you go down to your deeds and stuff. Those are personal agreements between people. Our zoning ordinance supersedes that if it's a stricter ordinance. That's my thought on that, but you should, I think you should talk to a lawyer about that, so don't take my word for that. Lastly, he comments on people renting. There is the gap. I truly believe that they can't show that there's a gap or not a gap. So if they rented, it could have been over a year between the rentings of those timeframes. And as far as putting the ordinance to it, I think it applies to whenever last he rented it. Like typically, we don't have to go all the way back. We can look at 2018. You can look at 2015 ordinance in order to say that that it was not allowed at that time.
Thank you.
Okay, so I think we need to do is, we need to look at what do we have for findings of fact, what we need for facts, which may give us a ground for requiring the continuance. So why don't we, does anyone else wish to speak for the moment? Okay, so we're going to discuss findings of fact before we close the public hearing. That way, those of you who are part of the public will have an opportunity to correct or add a finding of fact. Okay. So, okay. Let me get my. First finding of fact is that in this case, the primary question is whether or not the property is grandfathered. Okay, so first point under this particular point is that the Silver Shores charter allows rentals. Okay, so what we're missing actually is documentation of the actual date.
Which I think is one of the findings.
76. Okay, so show this to Kate so that she can verify.
Yep.
You want to see this too? In fact, let all the board members see the seal there. That's not an original, that's a copy.
I have the original in here. I made this photocopy for another legal matter we had with the
Oh, that's
association.
fine. Would you show the original to Kate? Okay, so,
So do you want to put in parentheses after HOA, which was established in
yeah.
December, I think it was, I saw December
What was it,
of
70s?
1976.
Well, it's, the year is sufficient for our purposes.
Okay,
Yeah.
established in 1976.
That's the association.
Yes.
Okay, which predates our zoning ordinance.